Okay. Hello, everyone, and welcome to this final session of the STARS webinar series on democratic constitution making between deliberative and crowdsourced forms of constitutionalism. We are concluding this series of webinars with a talk by Francesco Biagi on the Tunisian case. The title of this presentation is Constituent Processes and Populism, the Case of Tunisia. We are very happy to have an expert on constitution-making processes, democratic transitions, and North Africa like Francesco Biagi with us today. So it is really a great honor and pleasure to have you with us, Francesco. Thank you very much also from Giuseppe Martinico for having accepted our invitation. And Francesco Biagi is Associate Professor of Comparative Public Law at the Department of Legal Studies of the University of Bologna, as well as a Research Fellow at the Center for Constitutional Studies and Democratic Development. That is a center created within the School of Advanced International Studies of Johns Hopkins University in Bologna and the University of Bologna. Previously, he was a Senior Research Fellow at the Max Planck Foundation for International Peace and the Rule of Law at Heidelberg, and he was visiting professor at the College of Law of the University of Illinois and at the Faculty of Law of Tel Aviv University. And he was also visiting researcher at the Cardozo School of Law. He is the coordinator of the subgroup on Africa of the International Association of Constitutional Laws Research Group on Constitutionalism in Liberal Democracies, and he also provided technical assistance to the Constituent Assembly of Chile, the Convention Constitucional we mentioned with Professor Verdugo also. So he was involved in the constitution drafting process of Chile, and he has written extensively in English, Italian, and Spanish on transition processes, constitution building, forms of government, fundamental rights, and so on. But among his many publications, let me mention his fantastic book, European Constitutional Courts and Transition to Democracy, published by Cambridge University Press. So, having said that, it is with great pleasure that I give the floor to Francesco Biagi for his presentation. Francesco, the floor is yours, and thank you again for being with us today.
Thanks a million, Matteo, for this very generous presentation. Thanks a lot also to Giuseppe. Thanks a lot to both of you guys for inviting me. It's really a pleasure. It's really an honor to have the chance to to give a talk in this fantastic series that you have organized. So as Matteo said, in my presentation, I'm going to talk about constituent processes and populism, and I'm going to focus in particular on the case of Tunisia. Next slide, please, Matteo. In particular, my presentation will be divided into three main parts. First of all, I will talk about the process of democratic deterioration that Tunisia has experienced since the proclamation of the state of exception by President Kais Saied in July 2021. And I will also focus on another very important act adopted by Kais Saied, which is the presidential decree on the exceptional measures of September 2021. And as I will explain in greater detail, this is the most important legal act that Kais Saied adopted in order to impose his illiberal regime in the country until the adoption of the 2022 constitution. Then in the second part of my presentation, I will focus on the illiberal populist constitution making process. So the illiberal populist process that led to the adoption of the 2022 constitution, and this will be the bulk of my presentation. I will look at five main topics, 5 main areas. So I will look at the process, strictly speaking. I will look at the system of government. I will look at the territorial organization and the so-called bottom-up democracy, so the vertical separation of powers. But we'll also say something on religion and also on women. And then in the last part of my presentation, I will explain you why, in my opinion, Kais Sayed, who is a former university professor of constitutional law in Tunisia, should be considered an unconstitutional scholar. And finally, we'll try to answer the $1 million question, which is what's next? So what will happen, in the next few months, in the country? Okay, let's start with this process of democratic deterioration, with this illiberal turn. Next, please. Here, I think that is important to stress the fact that in the decade that goes between 2021, when the dignity revolution in Tunisia begins, until 2021, when we have the adoption of when we have the proclamation of the state of exception, during this decade, Tunisia, in my opinion, could be considered to a large extent a positive exception in the region, a positive exception compared to all the other Arab countries involved into the so-called Arab Spring, for a number of reasons. Tunisia was a country that held free and fair elections since October 2011, when we had the first elections, free and fair elections after the fall of Ben Ali, with the elections of the Constituent Assembly. This is a country that experienced a peaceful alternation of political parties in power, from Islamist parties to secular parties, and in some cases also coalition governments, which is something very remarkable, especially in the context of the Arab world. This is a country that adopted probably the most democratic constitution in the region, the 2014 constitution, or in any case, one of the most democratic constitutions, which is not a coincidence if you consider the fact that this constitution was adopted followed an equally democratic constitution-making process. In the second part of my presentation, I will focus on the process that led to the adoption of the 2022 constitution, but I will often make a comparison with the process that led to the 2014 constitution, which on the contrary was very democratic process. So during this decade, Tunisia was, at least in part, characterized by the principles of, the typical principles of constitutionalism, including the principles of separation of powers and quite a robust system of checks and balances. And also, it was also characterized by quite an effective protection for civil, political, and religious rights. And here I'd like to stress the fact that in 2015, Tunisia became the first country in the Arab region to be classified by Freedom House as a free country. All the other countries in the region, on the contrary, are either not free or, in the best case scenario, partially free. Between 2015 and 2022, Tunisia is a free country, according to Freedom House. And talking about that, we also should not forget the fact that thanks in particular to the 2014 constitution, women's rights and the principle of gender equality were significantly enforced. Next, please. Obviously, there were also many problems. There were also a series of shortcomings, a series of weaknesses, in this story. What were the main challenges that Tunisia were facing, before the proclamation of the state of exception in July 2021? Well, first of all, as I said before, there were instances of cooperation and collaboration between Islamists and secular forces. However, there were also cases, a series of cases of antagonism and polarization between, in particular, Ennahda, the main Islamist party in the country, and non-Islamists. So there were also tensions and conflicts between these two very important souls of the Tunisian society. Another super important element to be considered is the fact that some very important parts of the 2014 constitution had not been implemented. And here I'm referring in particular to two aspects. The first one is that there was a weak enforcement of the part of the constitution devoted to socio-economic rights. And the second problem was also that the Constitutional Court, which was supposed to be one of the most important institutional elements of the constitutional architecture in the country, was never established. And this would lead to a series of negative consequences, as I will show you in a second. But then the country was also affected by a series of problems that also characterized the country before the 2011 revolution, such as a high rate unemployment, a rampant corruption, and also new problems such as a very poor handling of the COVID-19 pandemic by the government. Tunisia was one of the countries in Africa that was, mostly affected by the pandemic. So the government in general was not capable to satisfy people's hopes for improved living standards, and the economic situation in general continued to be incredibly complicated. So in September 2019, we have the election of President Kais Saied. And President Kais Saied, since the very beginning of his presidency, started to rely on all the shortcomings, all the weaknesses that I've just listed in order to re-establish, any liberal rule. And I mean, this is, the typical strategy which is often used by populist leaders. They rely on the shortcomings, on the weaknesses, characterizing the society in order to establish or re-establish, any liberal regime. Next, please. The process of democratic backsliding starts in particular the 25th of July 2021. So we have a specific date when Kais Saied invokes Article 80 of the 2014 Constitution and declares the state of exception. Kais Saied was saying that there was an imminent danger threatening the integrity of the country. In actual fact, there was no imminent danger. This was just a justification that Kais Saied used in order to proclaim, this state of exception. But in any case, when he proclaimed the state of exception, he adopted four main measures. He dismissed the prime minister. He froze parliamentary activities for 30 days. So he suspended basically the activities of parliament for 30 days. And then this measure was renewed for an unlimited period of time. And then in March 2022, he even decided to dissolve parliament. So at the beginning, we only have a suspension of the activities of parliament. Then a few months later, we have a genuine dissolution of parliament. He also suspended the parliamentary immunity for all MPs. And he also announced that he would preside over the office of the public prosecutor. Now, even if you are not familiar with the 2014 Constitution, you can clearly see that most of these measures clearly violated Article 80 of the Constitution, which regulates the state of exception. Because on the one hand, this provision states that, and I'm quoting, the president can take any measure necessitated by the exceptional circumstances, but he also states, on the other hand, that the assembly of the representatives of the people, so parliament, shall be deemed in a state of continuous session throughout such a period, And in this situation, the President of the Republic cannot dissolve the Assembly of the Representatives of the People. So both the suspension of the activities of Parliament and the dissolution of Parliament represented a blatant violation of Article 80 of the Constitution. Next, please. Just a couple of months later, so 22nd of September 2021, Sayed takes a further step because he issues Presidential Decree number 117 on the exceptional measures. And this Presidential Decree, as I will show you in a second, really granted to Kais Saied full powers. Precisely the idea of full powers, the idea of the plenitudo potestatis, that when a leader gets, the unlimited authority. Here I have listed, some examples. So very briefly, all the competencies of Parliament remain suspended. Parliamentary immunity remains suspended. The President directly could exercise legislative powers. And remarkably, the decrees adopted by the President in order to exercise this legislative power could not be annulled by courts. So there was no judicial oversight over the action of President Sayed. Obviously, the executive power was exercised directly by the President, only with the assistance of a government. So the President adopted all key decisions in the country. He decided the general policy and so on and so forth. And the government was only responsible for implementing the decisions made by the President, only for enforcing them. And last but not least, the provisional body responsible for verifying the constitutionality of bills was abolished. So we also have the elimination of the provisional body for constitutional review, which means that also constitutional justice was completely eliminated from the system, from the country. So really a typical example of full powers. Next, please. It's very interesting to see what were the reasons justifying the adoption of these exceptional measures, because these reasons are clearly pointed out in the preamble to the decree. And this is really, in my opinion, is a fascinating, reading, because it is full of the typical populist rhetoric that we can find also in many other examples. So this decree, the preamble to the decree says that sovereignty belongs to the people, but the people were prevented from exercising it. So the typical abuse of constitutional notions, such as, the idea of sovereignty. The people had repeatedly rejected the existing mechanisms concerning the exercise of sovereignty. The functioning of public powers has been hampered. The danger is not imminent, rather it is real, especially within Parliament. And then my favorite one, the principle according to which sovereignty belongs to the people prevails over forms and procedures. So really a 100% populist discourse. We have, first of all, an opposition to the elite, to the so-called establishment. We have an attack on representative democracy. In particular, we have an attack on Parliament. This is very important. Parliament, since the very beginning, also during the electoral campaign of President Kais Saied, was depicted as one of the main problems of the country. He kept repeating that all MPs were corrupted, that what was necessary was to get rid of all these corrupted politicians. So he argued, he called for a direct relation between the President and the people, or to be more precise, the President and his people, as, for example, Nadir Binati rightly pointed out, in his book, Meet the People, how populism transforms democracy. So the idea that the relation is between the populist leader and just a part of the population, the part that supports the leader, not the entire population. And then, obviously, Sayed also relied on the typical Schmittian dichotomy, amicus hostis. On the one hand, there are, the people who are supporting me, my friends. On the other hand, there is the enemy. So all the institutions, all the people, all the trade unions, all the political parties that, on the contrary, are fighting against my political action. Next, please. Here I want to briefly point out also one important thing that has to be underlined, which is the following. The duration of the state of exception in the country entirely depended on Kais Saied discretion. This is very important to underline because, in theory, the 2014 Constitution of Tunisia had provided for a very important safeguard contained in Article 80. This article stipulated, and I'm quoting, 30 days after the entry into force of the exceptional measures and any time thereafter, the Speaker of the Assembly of the Representatives of the People or 30 of the members thereof shall be entitled to apply to the Constitutional Court with a view to verifying whether or not the circumstances remain exceptional. This article was taken almost verbatim from Article 16 of the 1958 French Constitution as amended in 2008. So the idea is that the President declares the state of exception, but 30 days later, the Constitutional Court can verify whether the reasons, whether the circumstances are still exceptional or not. So basically, the Constitutional Court had the possibility to check the constitutionality of the upholding of the state of exception. So it could declare the unconstitutionality of the upholding of the exceptional measures. However, this was not possible, in the case of Tunisia, because Parliament had been suspended and the Constitutional Court was not there. The Constitutional Court was never set up, was never established. There are many reasons why the Constitutional Court was not set up. One of the, probably the main reason, has to do with the fact that the political parties could not find an agreement, on the members of the Constitutional Justice, to be elected, to the court. But there is also another reason which has to do with the behavior of President Saied, because in April 2021, so a couple of months before the proclamation of the state of exception, he decided to reject a bill that would have reduced the number of votes required for the parliamentary election of 1/3 of the court's members. So originally, the quorum that was provided for was, in order to elect the parliamentary members of the Constitutional Court, was a quorum of 2/3 of Parliament, so 145 members. With this bill, this quorum would have been reduced to 131 in order to facilitate the election of this constitutional justice. But Kais Saied said that the Constitutional Court could not be established because the one-year deadline provided for in the Constitution to elect the members of the Constitutional Court had not been met. There is, in fact, a provision in the 2014 Constitution that stated that the Constitutional Court had to be elected within 1 year since the first parliamentary elections, which means the parliamentary elections were held at the end of 2014, so the Constitutional Court had to be elected by the end of 2015. Happened. So Kais Saied consider, this deadline as a peremptory time limit rather than just a recommended time frame. I mean, we are all lawyers, we are all familiar with deadlines, in constitutions, and the fact that, you decide to prevent the establishment of such a body, such as the Constitutional Court, arguing that we are dealing with a peremptory deadline, is a very poor reasoning, especially if you consider the fact that it comes from a university professor of constitutional law. But again, this is Kais Saied. Next, please. I will conclude this first part of my presentation stressing, a couple of aspects, two more aspects actually. The first one is that this presidential decree on the exceptional measures introduced a de facto super constitution, which was the decree itself. The decree itself, the presidential decree itself, became the real constitution of Tunisia that to a large extent replaced the 2014 constitution. And I will give you an example. Article 20 of this decree is really fantastic. I mean, it's very sad, but it's really fantastic, stipulated, and I'm quoting, the preamble to the Constitution, Chapter 1 on the general principles and Chapter 2 on rights and freedoms, as well as all the constitutional provisions which are not in contrast with this presidential decree, continue to be enforced. So this decree, the preamble to the decree, sorry, Article 20 to the decree, is not stating that the presidential decree has to be in line with the Constitution. It's stating the other way around. It's stating that the Constitution has to be in line with the presidential decree. You don't need to be unskelsen to understand that here there is something wrong, and in particular the fact that the hierarchy of the legal sources was completely reversed, totally reversed. The good news is that exactly 1 year later, since the adoption of the state of exception of this presidential decree, the African Court on Human and People's Rights declared this decree in contrast with the African Charter on Human and People's Rights. And in particular, the court ordered not only to repeal this presidential decree on exceptional measures, but it also ordered to return to constitutional democracy within 2 years from the date of notification of this judgment. Obviously, we are not naive, and we are perfectly aware of the fact that it is almost impossible that Kais Saied will comply with this judgment. But there are at least a couple of reasons why, in my opinion, this decision is important. The first one is that from a symbolic point of view, we have an international court, a regional court, the African Court, which has certified the fact that what Kais Saied has done is not compatible with the principles of democracy, constitutionalism, and the rule of law. This has been stated by an international court. The second reason is also a bit more personal, if I may say, because who is the guy who petitioned the African Court on Human and People's Rights? This guy is Ibrahim Belguit. And in fact, the case is Ibrahim Belguit versus Republic of Tunisia. Ibrahim Belguit is not only a close colleague, but if I may say, also a friend of mine. We have worked a lot in the country over the past few years. He's a lawyer at the Court of Cassation. I want to stress his name because it shows the fact that in Tunisia there are people who are really, such as Ibrahim Belguit, who are really brave, who are really courageous, and found the courage, to petition the African Court on Human Rights. It's not easy in nowadays Tunisia, to make this such a decision, because you immediately become a target of the regime. But he did that, and I want to emphasize, this aspect. Next, please. Okay, the second part of my presentation, as I was saying before, will be focused on the illiberal populist constitution-making process. So the process that led to the adoption of the 2022 constitution. Next, please. I will start in particular with the analysis of the process. And here, forgive me if I have to mention, quite a number of details concerning, this constitution making process, but I think it is important to show you how incredibly undemocratic this process was. We're clearly dealing with a top-down process. We're clearly dealing with a constitution imposed from above, imposed directly by Kais Saied. Everything starts with an online public consultation, which was held at the beginning of last year, at the beginning of 2022. Tunisian people were asked to answer various types of questions concerning institutional, economic, and also social issues. The turnout was incredibly low. Only 7.5% of eligible voters participated, to this online public consultation. And not surprisingly, the results, the outcome of this consultation coincided to a large extent with Sayed presidentialist ideas and visions. In particular, one of the questions was, do you want to replace the semi-presidential system with a fully presidential regime? We'll come back to this in a second. And obviously, 99% of the people who participated in this online consultation said, yeah, absolutely, we want that. Then on the 19th of May of last year, Sayed also establishes a constitution drafting commission, in particular a National Consultative Commission for a New Republic, presided over by Sadok Belaid. Sadok Belaid, as I will show you in a second, will become a very important actor, in this process. He was supposed to be the right arm of Kais Saied. He was supposed to be a strong ally of Kais Saied. But as I will show you, this was not necessarily the case. This National Consultative Commission was composed of 3 sub-commissions. There was a commission on economic and social affairs, there was a legal commission, and then there was a commission for national dialogue, which was composed of the members of the 2 previous sub-commissions. And this commission for national dialogue was responsible for preparing a first draft of the constitution. And this first draft of the constitution had to be submitted to President Kais Saied by June 20th. The problem here, there are 2 problems here. The first one is that many of the trade unions, of the civil society organizations, and also all the deans of the faculties of law and of political science that had been invited by Kais Saied to participate in this constitution making process refused to participate. They said, no, we don't want to participate. I spoke, for example, with some, not the deans, but with some professors at the University of Carthage in Tunis, and they told me that, they confirmed me that the dean of their university refused to participate because he did not want, the faculty to be perceived as non-independent by the population. And the same reasoning was made also by all the other deans. So from this point of view, it was a failure, this idea of trying, to involve different actors of the civil society failed. The other problem was the following. As I said, this commission was supposed to hand over to President Kais Saied a first draft constitution by June 20th. Okay, so consider the dates. Then on June 30th, so 10 days later, President Kais Saied had to submit to the referendum the final draft of the constitution. Next, please. So what happened was that on June 20th, actually, Sadok Belaid and the commission hands over to President Kais Saied the first draft. And then on June 30th, when Kais Saied submits, the constitution to the referendum, the people, actually Sadok Belaid, to be more precise, discovers the fact that the text that he and the commission had prepared was completely different from the text that Kais Saied had submitted to the referendum. And so Sadok Belaid immediately said, this is not my text. This is not the text that I prepared with the commission. It has nothing to do with that. And in order to prove that, he handed over to the press the text that he had submitted, to President Kais Saied on June 20th, to show the fact that it has nothing to do with the text that Kais Saied had published. So officially, nobody knows who really drafted this constitution, during these 10 days, between June 20th and June 30th. But it's almost certain that it was either Kais Saied himself, or, in any case, a small group of people under his direct direction. Things got even more problematic because 1 week later, on July 8th, Kais Saied issues a new presidential decree by which certain errors contained in the draft constitution published on June 30th were corrected. So Kais Saied said, we need to correct certain material errors. But in actual fact, again, if you read carefully, this presidential decree, you can see that in this decree, there was not only a correction of certain material errors, but Kais Saied also made certain substantive changes, to the constitution. So the process ends the 25th of July with a ratification of the constitution in a, let's say, referendum, in which 94% of the voters backed the new constitution. But again, the turnout was very low because only 30% of eligible voters went to the polls. It goes without saying that officially this was a referendum, but in actual fact, we are not dealing with a referendum, we are dealing with a plebiscite, in which, the voters actually simply ratified a decision that had already been made from above, directly from President Kais Saied. So the typical example of an autocratic plebiscite. Next, please. This process that I've just described is diametrically opposed to the process that led to the adoption of the 2014 constitution, which was, on the contrary, a profoundly democratic process. It was a bottom-up process. It was a bottom-up process because, first of all, the people had the possibility to directly elect the members of the Constituent Assembly, so direct election of the constitution-making body. There was a very high degree of participation by civil society, who really had the possibility to have a say, to influence the text of the Constitution. It was also a very open and transparent process. And not only because the meetings of the Constituent Assembly were open to the public, but also because before the final version of the Constitution was adopted, the Constituent Assembly released 4 drafts of the Constitution. And each time the Constituent Assembly released a draft of the Constitution, the people, the civil society, the political parties, the trade unions had the possibility to read the text and then to make proposals and recommendations in order to improve, the quality of the text. And then there is another super important aspect, in my opinion, that has to be considered, which is the following. It was, to a large extent, a consensual constitution. A consensual constitution because it represented a compromise between different ideologies, between different political parties, in particular, a compromise between Ennahda, the main Islamist party, and all the other secular forces represented in the Constituent Assembly. And the main political party, Ennahda, which had the relative majority within the Constituent Assembly, in certain cases decided to take a step back and to accept the requests coming from the other secular parties, also in very sensitive areas. So at the end of the day, it was really a compromise between Islamist and non-Islamist forces. There was also a major involvement of international actors. The Venice Commission delivered a very important opinion, and some of the recommendations of the Venice Commission were actually then incorporated into the final text of the Constitution. So, especially at the beginning, especially at the outset, this constitutional text of 2014 enjoyed quite a high degree of legitimacy. Then this degree of legitimacy decreased because there were, you know, those problems of enforcement of the constitution that I mentioned before. But at the beginning, the constitution was really perceived as the constitution of the entire country, of all Tunisians. Next, please. The second aspect that I would like to make reference to refers to the system of government, to the form of government. Because when we analyze, when we look at the systems of government in virtually all Arab countries, the situation is crystal clear, because we have an over-concentration of powers and over-concentration of authority in the hands of the head of state. So in the hands of the president or in the hands of the king. So we have sometimes, you know, hyper-presidential regimes, as in Algeria, Syria, or Egypt, or we have executive monarchies in which the king reigns but also rules. He's not only a symbolic figure, but he also has executive powers, in some cases even legislative powers. And this is the case of Morocco, Jordan, and the Gulf monarchies. There was only one exception, again, Tunisia, with the 2014 constitution. And why? Because Tunisia was the only country in the Arab region after the Arab Spring which introduced a real semi-presidential regime, which introduced, at least in part, a real separation of powers and a real system of checks and balances. As far as the form of government is concerned, this semi-presidential system recalled, at least in part, the idea of the semi-presidential system that can be found, for example, in France, where you have, you know, an executive branch which is split between, you know, the president of the republic and the prime minister. And in fact, also in Tunisia, you had both the president of the republic and a head of government, so a dual executive, a bicephalous executive, because they both exercised, you know, this executive power. And there was a reason for that. Tunisian drafters wanted to avoid an over-concentration of authority in the hands of just one person. So their idea was to have a system of checks and balances also within the executive branch. So they wanted the president to control the prime minister and the prime minister to control the president. That's why they introduced this same presidential system à la française. It was a conflictual semi-presidentialism because there were actually some tensions, in some cases even contrast between the president and the prime minister, but it was democratic because they respected the rules of the game. They respected the principles of constitutionalism. There was no serious attack on, you know, on the rules established by the constitution. Next, please. This democratic semi-presidential system was, however, completely abandoned with the new 2022 constitution. And here, and this is really particularly interesting in my opinion, what we have is, I defined it a sort of constitutionalization of the state of exception. You remember that I told you that when Kais Saied adopts the presidential decree on the exceptional measures in September 2021, he already replaces the semi-presidential system with an hyper-presidential regime. And so he basically, in this 2022 constitution, it confirms all the provisions that could already be found in the presidential decree on the exceptional measures. In some cases, you know, these provisions were even taken verbatim from this presidential decree. So really, when you read the 2022 constitution, you really have the feeling of the fact that Saied constitutionalized, you know, the state of exception. The situation now is super similar to the situation that can be found, for example, in Egypt, or that can be found in Syria, where you have, you know, a one-man rule, a one-man show. The president is the undisputed leader of the political system. Nathan Brown, who is a prominent political scientist who studied in depth, Arab constitutional systems, described the 2022 constitution as a one-man's document. Just to give you an idea of the extent to which this system has gone in terms of the non-existence of a system of checks and balances, consider, for example, that this constitution does not provide for an impeachment procedure. So it's not possible from a constitutional point of view, from a legal point of view, to get rid of the guy, to get rid of this president. Constitutional court, the competencies of the constitutional court were incredibly, reduced. And Kais Saied also decided to abolish a series of independent authorities, such as the Human Rights Authority, or also the Authority for Good Governance and Anti-Corruption. Again, the populist rhetoric, he starts the electoral campaign and the constitution making process saying that he wants to fight against corruption, and then he adopts a constitution in which he abolishes the Anti-Corruption Commission. Next, please. Another aspect, the vertical separation of powers, territorial organization, and bottom-up democracy. Again, if you analyze the electoral campaign, if you analyze the process that led to the adoption of the 2022 constitution, you see that Kais Saied kept repeating that he wanted a strong decentralization of powers, that he wanted democracy from the grassroots, and in particular, what he had in mind was to establish, a system that, at least in part, recalled the Gaddafi's Jamahiriya, the Republic of the Masses. So he wanted to have local popular assemblies in order to decentralize as much as possible, the power. But again, this is what he had promised during the electoral campaign and the constitution-making process. But then, if you look at the text of the constitution, you can see that there are very few traces of this scheme, because this idea of local assemblies is quite weak. There is just one brief reference in Article 75. Then Article 61 describes, regulates the so-called recall procedure, in Italian, the revoca degli eletti, so the possibility for the electors to revoke the mandate of MPs before the end of their term. And you also have a creation of a second chamber, the second house, an upper house, the National Congress of Regions and Districts. The vertical separation of powers is very weak. Now there is just one article devoted to local power. On the contrary, in the previous 2014 constitution, there were 12 articles that significantly strengthened, the vertical separation of powers. Now there is just one article, again, taken almost verbatim from the previous 1959 constitution, the post-independence constitution. So again, all the promises that he made then were not incorporated in the constitution. Next, please. A few words very briefly also on religion. Here is very difficult to explain what happened. So I will just tell you what happened concretely, even if I don't really have an explanation for that. So under the 2014 constitution, you had two very important provisions, namely Article 1 and 2. Article 1 stated that Tunisia, and I'm quoting, Tunisia is a free, independent, sovereign state. Its religion is Islam, its language Arabic, and its system is republican. And Article 2 stated that Tunisia is a civil state, Dawla Madaniya in Arabic, based on citizenship, the will of the people, and the supremacy of law. I would say that these were two pillars of the Tunisian institutional architecture. Article 1 stated that the religion of the state or the religion of Tunisia was Islam. This was not clear, because this article could be interpreted in two different ways. You could say that Islam was the religion of the state, so creating an identification with state institutions, but could also be interpreted in the sense that Islam was the religion of Tunisia. So the fact that 99% of the Tunisian population is Muslim, so stressing a more an identitarian, a more sociological aspect. From a grammatical point of view, in Arabic, when the expression "its religion is Islam" can refer both to the state and to Tunisia equally. So it was not clear, the interpretation. And then, even more importantly, Article 2, which stated that Tunisia was a civil state, Dawla Madaniya. In Islamic constitutionalism, when you use the expression civil state, you are referring to two things. First, you are referring to the fact that the state is not governed by the military, but is governed by civilians. And second, you are referring to the fact that the state is not theocratic. That Tunisia was not a theocratic state, but it was governed, again, by civilians, a non-theocratic state. These two provisions were completely abandoned, completely erased from the constitution, and were replaced by an article that has no equivalent in the Arab region or in the Islamic world at large. It is a unique provision from, in the entire globe, in the entire world. There is no other country that has a similar provision. It states, Tunisia is part of the Islamic Ummah, and the state alone, within the framework of a democratic system, must endeavor to achieve the aims or objectives, in Arabic maqasid, of Islam in the preservation of life, honor, property, faith, and freedom. So the first part of the article says that Tunisia is part of the Islamic Ummah. The Ummah means, the community of believers, the community of Muslims, all those who share the same faith in the Islamic religion. And then it says that the state must endeavor to achieve these aims, these objectives of Islam, Maqasid al-Sharia or Maqasid al-Islam. Here you have two problems. The first one is that the list of the Maqasid al-Sharia, the aims of Islam, mentioned in this article, do not entirely correspond, they partially diverge from what are traditionally considered the Maqasid al-Sharia, which are the preservation of faith, life, intellect or reason, property, and lineage. So you don't have a correspondence here. But for the purposes of this seminar, what is even more interesting is that it's absolutely uncertain, it's not clear at all what the effects of this provision will be on the Tunisian legal system. I mean, I've read really a number of analysis of this article by a series of commentators, both constitutional scholars, but also religious scholars. And you can find basically some scholars arguing that it is possible that with this new article and the elimination of previous Article 2, Tunisia can turn into a theocratic state. Other scholars have a completely different opinion, arguing that on the contrary, thanks to this provision, the state can become the real interpreter of the divine will. So Tunisia can hardly become, a theocratic state. Really, nobody really knows, what will happen, and we will have to see, the concrete implementation, if there is any, of this article. The only thing that we know is that just a few days before he submitted the constitution to referendum, Kais Saied announced in an interview that he wanted, to have a new constitution without a reference, of Islam as a religion of Tunisia or the religion of the state. And next, please. The last aspect that I will mention is the following: women, an aspect regarding women, the position of women in this new constitutional order. As I told you before, Tunisia was, in particular, thanks to the adoption of the 2014 constitution, particularly advanced when it comes to women's rights and when it comes to gender equality. I don't want to analyze these provisions in detail. The important thing that we have to underline is that I mean, the vast majority of these gender-sensitive provisions were actually reflected then in ordinary legislation. So there was, quite a correspondence between the law in the books and then the law in action, a concrete enforcement of these laws. For example, in the field of the electoral legislation. So, for example, in the case of the elections of the Constituent Assembly and parliamentary elections, they were based on the principle of vertical equality, according to which electoral lists must be drawn up in such a way as to alternate between men and women. So if the first candidate in the list was a man, the second candidate had to be a woman, the third candidate a man, the fourth candidate a woman, and so on and so forth. And this guaranteed quite a significant representation of women in elected institutions. The 2022 Constitution has confirmed, basically with the same wording, most of the key provisions on women's rights and gender equality. What is the problem? The problem is that at least some of these provisions now are no longer reflected in the implementing legislation. So, for example, in September last year, Kais Saied adopted a decree which changed the electoral system, and he eliminated the principle of vertical equality that I've just described. And in this way, not surprisingly, in the following parliamentary elections that was held between December 2022 and January 2023, the representation of women in parliament significantly decreased. So he announced the fact that he wanted to maintain, women's rights. He wanted to continue to protect women's rights. But then one of the first measures that he adopted after the adoption of the Constitution was, to eliminate this basically quota system for women. Next, please. Next again. So to conclude, just give me 3 minutes and I will conclude. Why Kais Saied can be considered an unconstitutional constitutional scholar? I think that basically it's already implicit, in my presentation. I would like to start, however, by recalling what Michel Camot, a prominent political scientist, stated commenting on the results of the 2019 presidential elections when Kais Saied won the elections. So he said, Kais Saied is not so much a constitutionalist populist, unconstitutionalist populist, a reassuring definition that smells of academic propriety, but rather a populist constitutionalist, unpopulist constitutionalist. That is, a populist determined to make his own idea of a constitutional prevail against winds and tides, as generally happens to populists once they come to power. And in my opinion, Michel Camot was perfectly right, because we have seen what Kais Saied since July 2021. We have seen that he has imposed, an illiberal rule, which was covered by a veneer of constitutionality. He wanted to give a constitutional look to his measures, supported by a strong populist rhetoric. The most problematic part of the story, in my opinion, is that the proclamation of the state of exception and then the constitutional making process, but also the adoption of the 2022 Constitution, which, as I've showed, moved the country away from the principles of constitutionalism, were presented by Kais Saied not only as perfectly compatible with democratic standards, but they were presented as necessary to restore or to ensure a restoration of the democratic order in the country. That's probably the most important reason why, in my opinion, we are dealing with a non-constitutional populist constitutional leader. Next, please. The $1 million question, what's next? It's very difficult to predict, almost impossible, but I think that there are a few things that can be said. On the one hand, I think that we can say that the support that Kais Saied enjoys now, hic et nunc, is certainly less strong compared to the support that he enjoyed in July 2021 when he proclaimed the state of exception. we should not forget that when Kais Saied proclaims the state of exception, the vast majority of the country is with him. The vast majority of the population backed, his action. Now the support seems to be much lower. First of all, because of an extremely low turnout in the various consultations that were held, in last year. So 7.5% in the online public consultation, 30.5% in the constitutional referendum, or just 11% in the legislative elections of December 2022, January 2023. Some commentators said that this is a war record, a war negative record for legislative elections, 11%. If it's not a war record, we are very close to it. The other element that we have to consider is that Saied does not have an institutional base or a party behind him. Kais Saied is an independent. Kais Saied is not affiliated to any political party. And this was one of his strengths, especially at the beginning. Now, what he does have, and this is very important, he has the backing of the security forces, both the police and the army. And in the Arab world, it is de facto impossible to rule without the backing of the army. And examples of Algeria and Egypt are very evident, but the case is also of Tunisia is also quite evident. The third element that we have to consider is that the economic situation in the country has further deteriorated compared to July 2021. Sometimes it's also not possible to find certain basic products in the malls, in the supermarkets. So now Saied, again, according to a typical populist rhetoric, is trying, to shift attention to other issues. The most recent, attempts is to attack sub-Saharan migrants, saying that they are threatening the Islamic identity of Tunisia. But then the question is, how is it possible then that the guy is still there, that the guy is still in power? In my opinion, there are two main reasons for that. And at least this is my opinion also on the basis of the conversation that I had with some Tunisian colleagues. The first one is that there doesn't seem to be a real alternative in the country, at least for the time being. Because if you look at the opposition, you see an opposition which is fragmented, very fragmented in some cases, and you also see politicians that had already ruled in the past and who had failed, who were not able, to deliver, who were not able, to address the problems that the country had. And that's why people trusted Kais Saied. But now how can they trust, these old politicians? And then the second problem, which involves also Europe, strictly speaking, is that if you look at the strategy of the European Union and of European countries in general, is that they are not exercising any kind of pressure on Kais Saied, because for an obvious reason, because they fear that this would create instability in the country, and this, might increase migration towards Europe. We all know that now, Tunisia is the country where most of migrants, come from. The migrants coming from North Africa. The vast majority of them, come from Tunisia. Imagine a situation in which there is not an effective government in power, a situation of anarchy or semi-anarchy in the country, or even of a civil war. This would, create, further instability, and obviously the flux of migrants would be even bigger. Apologies, I spoke for too much. Thank you very much.